Hey everybody, good morning. I'm JD Houvener, host here for the Bold Today show, and you've made it to our live broadcast. We're publishing across Facebook, YouTube, as well as our LinkedIn audience. So excited to have all three stations here with us. If you're tuning in live, welcome. This is great. This is for you. I want to make sure you prioritize any live questions you've got related to patent law, entrepreneurship, anything intellectual property, including trademarks, copyrights, and even trade secrets. Bring all your questions. Do keep them hypothetical. This is not a confidential attorney-client privilege discussion today, but want to make this lively and as participative as possible. So what I'll do is put a quick legal notice for those of you that are new to the program. Just please don't share your invention here on this program. That's not what this is about. But I'm happy to answer any questions you've got about maybe you're halfway through the process and you're stuck, or you're just wondering if something you thought about is eligible. And asking what does it take to get into the process? What do you need to get started? Those are the kinds of questions that we can definitely answer here. For those of you that are tuning in from our avo.com answer bank, thank you for sending in those questions. I'll be getting to that at the end of our show. So tune in for that, and please just stay in with us, and feel free to ask any questions as we move along. So for those of you just joining in, I'm JD Houvener. I'm the owner and founding partner here at Bold Patents Law Firm. We are a patent boutique, and we help inventors, startups, small businesses alike to get their inventions researched, affirm that they are patentable, and then help you apply for those, navigating through the USPTO examiners, working on behalf of you to get that all the way through to grant. So we are here on your behalf and invention advocates. Thanks for those thumbs up. And please do share this with anybody you know that might be an inventor out there, maybe aunt, uncle, cousin, brother, sister, trying to get this to be a more vibrant weekly show to get you pumped up and ready to go as we get toward the end of the year. I know a lot of people are checking off their lists before holiday season hits too hard. This is the time. So what I'll do is provide you a link to schedule a free screening session. Again, this is a free, pretty low barrier in terms of commitment, but it's a nice discussion to have with one of our advisor team to see if what you've got is not just an idea, but you actually do have an invention. And if now is the time to get started. So there's the link. It's our Calendly link to go hop on our schedule and get started today, right? It's a 15-minute screening session. And if you take action, we'll give you a copy of this book behind me, Bold Ideas, The Inventor's Guide to Patents. If you want to get hold of me personally, thanks to enter. What I'll do is I'll provide my personal email and a text-only phone number to get hold of me directly if you do have some of those more confidential questions. All right, so that is coming through the comments. Satender, there you are, you're welcome. Okay, let's jump to our topic of the day, which is ABC, the ABCs of patenting. And again, if you have any live questions as I go through this broadcast, I will be checking in to see and trying to respond to those as soon as I can. All right, so let's do those ABCs. I've got a spreadsheet, not a spreadsheet, a slide deck I'm going to share with you guys. So I'll share my screen and we'll start from there. All right, so ABCs, patent application process flow. Yeah, it's a lot of words, I know it's a lot. Let's start from the very left side over here, okay? The initial consultation, and this is really important that we start right up front identifying eligibility. Not all inventions, discoveries are eligible. Most are, there's a lot that is, but things that aren't eligible are things like laws of nature or natural phenomena, right? Things that are part of the human body or that are actually ingrained in the way that physics work, right? And so those aren't actually things that are made or discovered that are the human ingenuity. It's more of just a fact, right? It's an equation, it's it's something you've discovered in terms of the law of nature. So those things or inventions that are too abstract, in other words, those that you really can't apply to a practical application, those are not going to be eligible for patent protection. That is the main criteria. So we'll have a discussion about what you've discovered, what you've invented, and that's the threshold question there, the initial consultation. Also, at the initial consult, right, you're actually before step A here still. We're going to talk about inventorship and ownership. It's so important to think about who is the inventor. Okay, and invention is who is the one or people, right? More than one person that came up with that first spark, that first creative energy and the conception. that is the inventor, right? It's not always, and typically not the engineer, let's say, that actually helped to bring it about or made the first prototype. The inventor is one that was the designer, the architect, the ones that put the pieces together mentally or figured it out and solved the problem. Whether they built it or manufactured it doesn't necessarily mean they're an inventor. So we have to straighten that out. And oftentimes there is some consideration with respect to ownership. If, for example, there is an employee or if someone has a day job and they've invented while on the job, we need to make sure we're clear in terms of who will own the invention should they decide to move forward with it and secure that asset. Most employers will own, in terms of their employment agreement, any invention that happens and occurs while they're in the scope of their employment. So if it's on the job, related to the job description, most likely it'll belong to the employer. And also we talk about long-term business goals. I mean, it is important that we have a firm grasp with our clients about not just getting the patent, but how they're going to be making money, right? What is their plan to enter this into the market and try to do our very best to make introductions to professionals or others in our network at the right time while they're getting this patent granted, so they can put it into the process and actually get it into the market and make an impact that they're looking for in the world. So let's check back and see if I have any questions from our streamer community on that initial pre-step A. All right, let's check back. I'm glad we have some viewers here. So let's now start on step A of the ABC process. We've gotten so far through this initial consultation, which is one of a very key part of this, and it's before we actually get to step A. But you can't miss this, all right? And this is having a patentability search and opinion done. And working with a law firm like ours, we do take 4 to 6 weeks to get this done right. It answers the big question of, is my invention patentable? Can I get a patent on this invention? Is it something that the examiners will say thumbs up to and say, you're good to go? And that does take time. Our attorneys will hire a third-party search team to look the world over to make sure that what you've got is indeed new, not an obvious version of something else that's come before it, and that it has utility, okay? So those are the 3 big requirements to getting a patent. And so we look in advance. Before we write an application, before we get spun up and tell you that it's an amazing idea, step A comes first, okay? And then that is that all-important $1 million question of, should I file, okay? Even if it's patentable, we look at the scope of rights. That scope, don't miss that, is what is it that we project that we could actually get you a patent on, given all the prior art, all the publications and the research and the information available to the examiners and to the general public in this field. What do we think we can get in terms of actual rights? Meaning what can we lock in and have you own at the end of the day? And then it's a decision, of course, as the inventor, potential business owner, right, of this technology, is do you think there's enough of a market for that scope? And do you think it's worth what could be tens of thousands of dollars in acquiring that patent asset? And we help you think through that very carefully. So that's step A. Unbelievably, there's so many law firms and professional, patent service companies that will forego step A, and they'll just jump to filing, right? File that application, and in a lot of ways, you get caught before the horse, right? You end up filing an application. It's not as well thought out, and in fact, you haven't done the research to see if it's even new. And so, in many ways, you've sort of wasted the money filing, claiming, patent pending status, and getting investors or even other people involved with their money without it even looking over to see if anyone else has done it before. So it could very well be that it's already been filed by another company, or there may already be a patent secured on that technology, and you may end up having to face an infringement suit from another company. So always best to start with doing some research and diligence up front with step A. All right, let's check back in and see if I have any questions on that step A. Nothing yet, but I'm glad to see we've got a few good live participants. So let's keep cruising through to step B. All right, step B here is the provisional patent application. And you don't always have to file a provisional, but for most first-time inventors, this is a very, I'd say, important part of the process. Because what it does is it provides you a full year. Once you file that, once at the end of step B, which does take about 6 to 8 weeks to write the application. You then have a year to file the non-provisional patent application. And this is the formal, final submittal that will then be sent off to the USPTO. The provisional allows you that whole year to begin to have conversations with third parties, manufacturers, investors, and to start really testing your invention, confirming that it not just impresses you as the inventor, but also there's a market demand for it. And you can sort of start to get some motivation or momentum, I should say, in the marketplace to see if it's something you want to move forward with. Yes, of course, you do get that patent pending status, which is wonderful, and it should be labeled on any products that you make or any digital renderings, brochures, websites, any type of animation you do. You want to make sure you signal and give that notice that there's patent pending on that product. In the provisional, it's super important, right? And again, another reason why you want to do that search, that step A, is so you can draft the patent application focusing on just what's novel. So if you hadn't done a search, you wouldn't really know what specifically makes your invention unique or what we think we can get a patent on. You'll talk about the whole invention. Well, after doing the search, we'll know that to focus on just 2 or 3 key aspects of the invention and to really go deep on those and to write additional paragraphs or pages, maybe, on those different embodiments, versions, structure, application, so that we can then look for that later to make the claim. So once you finish with the provisional, again, you have up to a year. You don't have to wait that full year, but then you can file what's called the non-provisional. And this is a formal, it has a very specific way that the writing must be laid out and the specification. The drawings have to be drawn in accordance with the rules. Whereas the provisional, yes, you should and can submit drawings, but they don't need to be formally done. In fact, you can submit photos, sketches, really, it's quite informal. But here at the non-provisional phase, they have to be drawn in accordance with the rules, clearly drawn, labeled, and back on the specification, they have to coordinate. Each of those flag notes or numerical markings have to match the specification. The all-important claim language, which is what at the end of the day, you're saying that you, the inventor, own. That is what the examiner will look at, word by word, sometimes syllable by syllable, to see if indeed you actually are the first one to invent that claim. And so that claim language must then be supported by the specification and the drawings. And so there's additional scrutiny over whether those claims have been supported, right? Did you actually provide enough explanation and definition and enabling description of what you're claiming as your invention? All right, so that is the step C, that's the big finale, and it does take several weeks to get that done right, revising the spec. And one of the coolest things about doing it in this way, with the provisional, then non-provisional, is that in that up to 1 year, which is probably more like 9 months to 10 months, you've learned a lot. Hopefully you've done some testing, spoken with third parties, maybe even raised money, and brought on some other technology, maybe to integrate or test what you've done. And no doubt you've learned a lot about it. And so those learnings, those improvements, those details, additional details about your invention should be added to the non-provisional. So your spec gets to be updated, refined, and more support and evidence and structure to help support the claim language that you'll be importing here at this stage. So that's the ABCs of the patent application process. Of course, there's a whole host of other steps that happen once you submit it to the patent office, but that's for another day. So that is a wrap on ABC. Let's see if we have any questions or comments on that. Suma, can we get access to this video or slides for future reference? Yeah, absolutely, I will provide that. I think it's on our website, but if it's not, we'll send a link out. Okay, let's see if there is one. Actually, take a quick look here. Yeah. Here we go. So this blog article here, how to patent an idea in 13 steps. This lays it out pretty clearly. And you can download those slides right there from this page. All right, I'll share that link out. Thanks for your question, Suma. So check out that link right there. You can get a full article and a blog article discussing what I just talked about in a lot more detail. And there's a picture you can click on and download, which is the slide that I just showed. All right, cool. Well, keep those questions coming. I'll jump to those if I see them. But for now, I'm going to go to our avo.com questions and see what we had come in this week. We'll take this one patent application question, and this one is out of New York, New York. Yeah, I'll bring this up on your channel so you can see it. All right, here we go. So when is the right time to get an attorney to patent my invention? An invention not yet in progress, but I want to start manufacturing it. So I just want to know, when can I start looking to involve an attorney? I'll bring up the full question here. Yeah, I mean, honestly, kind of using that ABC flow chart, I didn't actually set this up, but it's a perfect question for the slide I just showed. As soon as you have an idea, right? As soon as you have got something you believe that is not out there in the world, and there is a solution you found that solves this problem, and it's the first one that you've seen, right? And this is even more true for those that are in the industry, where you would probably know about anything else already out there. So if you have an inkling that you're really the first to move and you feel like you found a solution, you don't need to prototype. You don't need to go build it, as long as you've convinced yourself that you could. So I'm going to say that again. You don't actually have to go build it before you seek patent protection. As long as you're certain, just confident, I should say, that you could, if you had enough money, resources, time, you could go build it. You're confident that it could be built, and you know how to go perform it. You don't actually have to build it before you try to seek patent protection for it. So I would say, as soon as you're there at that conception point and your confidence is there that it's conceivable, I would reach out and speak with a patent attorney. They can then take down, right, all of what you've thought about, all of what you've discovered, and then start that process of researching to confirm indeed that yours is the first of its kind, and to see how different it is from what else has been published, researched, and patented before, to give you a really clear understanding of, here's what we think we can get you a patent on. And hopefully that's really exciting. And then you can move forward with, make that application, file first, right? The patent office rewards inventors that file first. The patent law has changed in 2013. It actually doesn't matter who invented it first. As of 2013, the American Invents Act changed it to whoever filed it first. So do the research, get it filed, then you can go start building it, right? Manufacturing it, refining it, getting it to where the point of perhaps even market ready, and start to do some beta testing and then confirm what you've built. All right, so that's a great question. Thank you for that. All right, so I will go to our next Avo question here, and this is in the trademark domain. We have 8 on trademark application questions. This is a pretty popular topic here. So this one is out of San Jose, California. Okay, so it is, how can I name a company and products from a legal point of view? I'm planning to have an app named Mall 2020 and a company named UApp as LLC. How can I protect the product and the company? Cool. Now, I get this question quite a bit, and I don't mind answering it because I think it's very important, right? I think it's great that people understand and appreciate the idea that you need to set up a company, form what's called an entity within your state. And one of the underlying principles there is that you get to have some limited protection, limited liability. And so forming a company, forming a business, whenever you're going to start selling products or hiring people and increasing your level of risk, right? Where someone might actually be able to say, your product is inferior, it caused me damage, right? So instead of them being able to come after you, the owner, personally, and you having to be liable for damages personally, your company would be liable, which is awesome. So an LLC, a limited liability company, is a fantastic mechanism to do just that, and done properly, okay, asterisk, meaning you've set up a separate business account, you've hopefully hired a business attorney locally, or at least gotten some counsel in terms of how to form the company properly. There's an operating agreement set up. You've got all those rules set up so that you truly can have that shield, that corporate gazette, as it were. Then it's good, right? It's very useful. With trademark law, it is totally separate from the idea of forming a company. And so the actual name, right, whether it's a word mark or like we have like a logo up here, it is so totally separate from the actual company, the LLC name. So our LLC as a law firm is Bold IP. PLLC. It's a professional limited liability company. But we used to be Bold IP. We used to brand that way as well, but we were now branded as Bold Patents, which is different than Bold IP. And so they don't have to be the same at all, is what I'm kind of getting at. So the business name, if you're going to be putting your actual name, I think you said it was UAPPE, UAPPE, as the name of the LLC, right? If you actually want to promote that and you're going to show UAPPE, however you say that, on your products, on your software, on the app, then yeah, you may want to get that protected. But it sounds like you're actually going to be using MAL 2020 as what you hope your customers remember and think about your app. And so MAL 2020, that's what you should seek trademark rights on. And assuming you can go through the process of doing the research on that trademark and getting it registered, you want to then assign that to the company. So the company will own the trademark asset. Hope that helps a little bit. So don't get confused in terms of having to get two separate registrations, one for the company name and one for the app name. Just put yourself in the customer's shoes. What will they be seeing, right? What are they going to know as the source of services and goods? That's what you want to try to protect with trademark law. All right, we'll do one more question, then we'll wrap up, everybody. So bring in those live questions now, just a couple more minutes, and then we'll look to close up. We'll do, here's one out of New York, New York. Okay. So a question about books. All right, good. So do I need an attorney to file a trademark? I want to trademark the name of my business. We'll be selling t-shirts and books. Do I need to file two separate trademarks? One for class 16 and one for class 25? And should I hire an attorney to do so? Well, the beauty of having a trademark attorney is they're going to come in with information on how are trademarks currently being litigated and what is the best way to set up your trademark application and process it such that it's ready if ever you had to defend it or enforce your rights. Okay, and that's the beauty. I should also mention, right, just like I showed on the ABC patent flow, there's a very similar flow for trademarks. Whereas if you forget to do that research up front and see who else has trademark rights in using that name or something similar, you might just be wasting your money applying for a trademark with the same or similar sounding name for someone in the same industry or the same classes. So you mentioned class 16 and class 25. I don't have all those classes memorized. I do have a trademark attorney on staff, and he's wonderful. He would have a lot more familiarity with those classifications. I do believe that you can file for several classifications at the same time with one application. The kicker, can be a kicker, especially for new companies that haven't sold their products yet, is that in order to get a registration, you do have to provide a specimen of use. And all that means is you have to be able to provide the trademark examiner evidence that you're using or selling products under those classifications. You have to show perhaps a website, right? So that you're actually marketing and have sold a t-shirt, right? Some apparel. And you also say books, so you've sold books on your commercial website using the mark, either the word mark or the logo that you're trying to get protected for under Bold. So as long as you have that, and it's not going to be hard to get, then you'd be safe. And I'm sure that'd be a useful practice. But again, reasons for using a patent attorney, getting a legal opinion on before you get started, is this a mark that's going to be protectable, right, registrable, before you just fire away blindly. And then secondly, as you go through the process, the writing and actual, the very careful language of how it's depicted, if there's any disclaimers needed, and just overall knowing that you're not going to just get a trademark registered without thinking about how it's going to be enforced, because that's really when the rubber meets the road. If you have a competitor or someone else who says, I'm going to use the same name, and if you haven't thought about how that's going to be enforced or how you would need to, how it would be litigated, then you'll be in trouble. So having a trademark attorney will help you think through that, sort of getting a trademark ready for enforceability. All right. So I didn't see any final questions come in, so we will wrap up. If you didn't get a chance to ask, oh, here we go. We have one question coming from Arturi Sulin. All right. I don't understand how you have so few spectators, even though your videos are so good and informative. Ah, you're awesome, Arshuri. Well, be an advocate, right? If you have any network on YouTube, social media, Facebook, whatever, send it out. I'll be here every week. I'll be here for as long as I can doing these broadcasts. So I hope to get more and more people. I'll just keep showing up. What's interesting is actually over the past 5 months, and it's embarrassing, I had been broadcasting to the wrong YouTube channel, because there's a bold patents channel, and then there's a individual one for me personally. Our YouTube channel has 5,000 subscribers, and we're very blessed to have that many people. So anyway, been broadcasting to the wrong. This isn't me, my trouble. But finally we're finally connected to the correct YouTube channel. So hopefully we'll get more people watching and have this be more of a lively community. So if you know someone and maybe you missed us this time, I'll be back next Wednesday, 9 o'clock Pacific and noon on the East Coast, and everywhere else where those time zones meet around the world. So happy to have those of you who ask questions. Thank you for the kind words, Arshuri. And I'll be back here next week. So take care, everybody. Have a good rest of your day. Go big, go bold.